Hello, everyone, and welcome to this week's Marine Money webinar presented by the high-ranking Oslo headquartered law firm Wikborg Rein. Today's webinar is titled Notification is Critical, the Prevention Principle, Delay and Extensions of Time under Shipbuilding Contracts. I'm your host, Andrew Oates, tuning in from our Marine Money office in Athens, Greece. And today I have the real privilege to introduce to you our presenters. Mr. Robert Jardine-Brown, partner at Wikborg Rein's London office and part of the firm's shipping and offshore practice, and Mr. Alex Hookway, senior lawyer at Wikborg Rein's London office and also part of the firm's shipping and offshore practice. Today's presentation will focus on the recent High Court guidance in the Jiangsu versus Precious Shipping case, which considers the application of the prevention principle, delay and extensions of time under shipbuilding contracts, and how it will differ from the previous judicial authority in the Zhoushan Jinhaiwan Shipyard versus Golden Exquisite case. The audience will get a better idea of how the English courts apply the prevention principle to shipbuilding contracts, how to seek and agree extensions for delay, and what common contract management pitfalls to avoid. Before I hand over the floor to Rob and Alex, a couple of ground rules. The audience will be on mute during this webinar to ensure quality control, and during the webinar, you should have a control panel which pops up on the right of your screen, as you can see here. There are two actions you can take today. First is to ask a question. To do this, you simply need to enter your question in the box at the bottom of the control panel where it says questions. I will receive them, and at the end of the webinar, I will ask the questions on your behalf. The second major action is to collapse the menu by clicking on the little arrow on the top of the control panel. I will now hand over the floor to Rob and Alex to give us some more insight into the application of the prevention principle. Robert?
Thank you. Thank you, Andrew. Thank you for the kind introduction. Good morning and good afternoon, wherever you are. It's good to have you with us. Alex and I have the enjoyable task of taking you through the recent case in the English High Court from April this year, so very, very recent, which makes a number of important findings in respect of shipbuilding contracts and the management, of such contracts. Before delving into the case, we thought we'd just give you 30 seconds on who we are. As Andrew said, Wikborg Rein is a full-service international law firm headquartered in Oslo, with over 200 lawyers worldwide, and with offices in Oslo and Bergen in Norway, and then in London, Singapore, and Shanghai. In London, where Alex and I both operate, we are 25 lawyers, and we focus on all aspects of shipping and offshore matters, including renewables, both in respect of contentious and non-contentious projects. But enough about us, and on with the case analysis. Slide 3, I think, Andrew, would be great. Yeah. So primarily, we're going to talk about the prevention principle, which was one of the key issues in this case, the Jiangsu case, and it was whether it applied. Now, many of you may know about the prevention principle, but it's a general principle on the construction of contracts under English law, and broadly derived from the well-established proposition that a party cannot, in the absence of clear terms, take advantage of his own wrong. It's seen more in land-based contracts than in the shipbuilding sphere, but given that shipbuilding contracts are similar, it's been attempted to be applied on a number of occasions, mostly unsuccessfully. But in principle, where an employer prevents a contractor from completing its work within the specified time, and there is no extension of time provision in respect of the act of prevention carried out by the employer, then the consequences of that is the employer cannot thereafter seek to enforce the time frame within the contract. Time will be at large, and it will not be entitled to claim liquidated damages and or cancel the contract unless the contractor subsequently fails to deliver within a reasonable time. So it's quite an important principle when applied. in a recent case in 2018, Coulson LJ in the North Midland Building Limited v. Siden Homes case clarified that the principle operated as an implied term, and he summarized the impact of the principle as such. If the parties do not stipulate that a particular act of prevention triggers an entitlement to an extension of time, then there will be no implied term to assist the employer, and the application of the prevention principle would mean that on a happening of that event, time was set at large. And it's this principle which was at the centre of the issues that needed to be determined by the English High Court in the Jiangsu case. Next slide, please, Andrew.
It now falls to me to introduce some of the facts of the case. I can disclose I was involved in this case in the underlying arbitrations between January 2017 through December 19 before I relocated to London. And whilst the High Court case shed some light on the issues which came before the lower tribunals, there are many aspects of these cases which remain confidential. So in broad terms, a series of 14 SAJ form with some amendments were entered into between Precious Shipping as the buyer and a now defunct Chinese yard, which was then subsumed into the Jiangsu Corporation at a later date. The terms were common in the market with the usual amendments. Of those 14 bulk carriers, 11 were started construction and were subsequently arbitrated. The buyers accepted delivery of hulls 9 and 10, the first two in the series, but hulls 17 through 20, the subsequent 4, were rejected to the buyer due to alleged defects. Those defects were not considered in the present case. The builder stated that the rejection was wrongful and the rejected vessels occupied space in the yard, which caused delay to the subsequent constructions of hulls 21 and 22, which is the subject of this High Court matter. This was the alleged buyer-induced delay. On the 29th of January 2016, which is 151 days after the contractual delivery date, the buyer terminated the SBCs for hulls 21 and 22 pursuant to their contractual right to terminate after 150 days of non-permissible delay. Can I have the next slide, please, Andrew? On the 3rd of February, just a few days later, the buyer claimed repudiatory breach by unlawful termination, as the buyer's termination right had not accrued, given that, they alleged, the builder was entitled to extensions of time for modifications. The builder had been prevented from delivering hulls 21 and 22 in accordance with the contractual terms as a result of the buyer's wrongful rejection of the earlier vessels, which is the prevention principle argument, which Rob will consider in greater detail shortly. The buyer's position in turn was that the SBC contained a complete code or circumstances in which they allowed the builder to claim extensions of time if they used the contractual machinery. The buyer contended the builder had not exercised the contractual machinery for those extensions and therefore were not entitled to any extension of time. The tribunal found in favour of the buyer, and the builder sought to appeal to the High Court under Section 69 of the Arbitration Act. A very small note on that for those who are not aware of that. As a matter of public policy, the High Court is extremely reluctant to get involved in underlying arbitration agreements between the parties. And unless the arbitration agreement specifies in particular that the right to appeal to the High Court is excluded, there are only very limited grounds on which a party can raise an appeal to the High Court, one of which is Section 69, which is when it is on a point of law. Just to give you an idea of how reluctant the commercial court is currently to engage in arbitration matters where the parties have clearly agreed to arbitration. In the court year 2018 to 2019, which is the most recent data available, there were 39 Section 69 appeals, of which none were successful. And that takes me over to Rob for the prevention principle.
The next slide, please, Andrew. So the appeal was concerned with various issues, of which the four main ones were: one, whether the prevention principle applied to the shipbuilding contracts. Linked to that was whether the builder had to give notice of delay events as a precondition for relying on such events when the buyer sought to terminate for accumulated delay. Thirdly, was to look at the contractual position with respect to modifications. And fourthly, the contractual scheme provided for in circumstances in which the buyer defaulted in its obligation to make pre-delivery instalments, which was also an issue in this case. Andrew, next slide, please. So the first issue, which was whether the prevention principle applied to this shipbuilding contract, and it was accepted that neither party should prevent the other from performing its obligations under the contract. And on that basis, the judge stated that the central issue which arises here is whether Article 8.1 is wide enough to cover this cause of delay. If it is, then express provision has been made for an extension of time and the prevention principle will not apply. So in a sense, the builder claimed that time was set at large due to the unlawful rejection of hull 17B and 20B, which had resulted in the occupation of the berths at its yard and the consequent delay to hulls 21B and 22B, which, as Alex said, was what they said was an act of wrongful prevention on the part of the buyer. And so the question was whether this buyer-induced delay fell within Article 8.1. Now, we set out Article 8.1 there, and it starts off as a traditional, what looks like a traditional force majeure clause, which states that if at any time before actual delivery, either the construction of the vessel or any performance required hereunder as a prerequisite of delivery of the vessel is delayed due to war, blockade, revolution, etc., etc. So typical events of force majeure. But then it goes on to provide a sort of catch-all, which is or other causes beyond the control of the seller or its subcontractors, as the case may be, then the time for delivery of the vessel under this contract shall be extended. Now, the relevance of whether or not this is a force majeure clause had been looked at in the Zhoushan and Golden Exquisite case back in 2015, and Leggett J in that case considered that the clause was simply a force majeure clause, at such that the wording highlighted there, or other causes beyond the control of the seller or its subcontractors, as the case may be, was referring simply to other events similar to those set out before it. So other force majeure events, if you like. Next slide, please, Andrew. The judge in this case took a different approach. Butcher, J, considered that the wording of Article 8.1 was wider than a force majeure clause, and the phrase or other causes beyond the control of the seller or its subcontractors, as the case may be, should be given a natural and wide meaning so as to cover any alleged buyer-induced delay. He stated that the clause itself wasn't referred to as a force majeure clause, and that the wording should be looked at in its natural or the natural meaning of the words, and therefore it should be given its wide meaning. He stated his view was that there was no ambiguity about this, but he also stated that the case law in the prevention principle identified that where these clauses were ambiguous or had some ambiguity, they ought to be construed in favour of the contractor, such that the contractor would then be entitled to rely on it where there were events of buyer-induced delay. And he also was, I think, also it's consistent with his view that shipbuilding contracts tend to provide a complete code for delay events, such that there isn't intended between the parties to be events that fall outside a contractual mechanism for entitling one party or the other to, or in this case, the builder, to claim an extension of time. So in doing so, he made it clear that there was no room for the application of the prevention principle under this contract, but more importantly, he stated that there was no room for such principle under any shipbuilding contract which had similar wording, which puts another nail in the coffin of applying the prevention principle to shipbuilding contracts if it wasn't closed already. So not a great decision for the seller in this case, but our view is that it's a good decision more widely and a positive development because it provides further clarity for the parties such that where this wording exists, any delay that the buyer causes, the builder has an opportunity to claim delay and claim an extension of time in respect of such event. As I said earlier, this was a finding, or the judgment was contrary to what Leggett had found in the Zhoushan case. And so perhaps unsurprisingly, Butcher gave permission to appeal, and the appeal is expected to be heard by the Court of Appeal in November of this year. Next slide, please, Andrew.
So this now takes us on to the second issue before Butcher J, which was notification. I mean, as Rob has already explained and described, the SAJ form as amended between commercial parties is a very sophisticated contract, which has great scope for extending and changing the delivery schedule. And the important bit behind that is communication between the parties. Now, the issue for the second issue to consider was whether the builder had to give notice of delay events as a precondition for relying on such events, such as buyer-induced delay, where buyer sought to terminate for accumulated delay. And the key contract clause is Article 8.2, which we reproduce there, which is of a standard forms in SAJ. It's notable that on this occasion, the builder did not issue any SBC notices in respect of Article 8.2. I think it's also quite important to actually consider the particular issues before the tribunal before we go on to Butcher's treatment of the issue. Now, the tribunal found that this notification issue embraced a number of sub-issues, namely, one, whether a failure to serve notice under Article 8.2 allows the buyer to ignore permissible delay in the calculation of the cancellation date. Two, whether service of a notice under Article 8.2 is a condition to any extension of time under Article 5.1 or Article 11.4a, and I'll come to that point in particular later on in the talk. Or finally, three, if not, in case of modification under Article 5, if no agreement is reached as to the extension of time for delivery, whether the seller is prevented from claiming any such extension of time, and two, in the case of default by the buyer, which I shall also cover later, whether the seller needs to do anything in order to postpone the delivery date under Article 11.4a. The tribunal's answer on this was resolutely no. The seller was not entitled to extend the delivery and or cancellation date in circumstances where it failed to and or did not operate or exercise any of the relevant contractual machinery. Next slide, please, Andrew. As Rob has explained, Butcher considered that the cause of the delay fell within Article 8.1, giving Article 8.1 a far broader interpretation than Leggett in Zhoushan. As a result, the notice regime on his reading under Article 8.2 would be triggered. But Butcher went on to give some rather interesting guidance on the ambit of Article 8.2, and he decided that if notice is not correctly given, the builder cannot claim the extension of the delivery date in respect of Article 8.1, but further, that this would be the case even if he was wrong about the broad interpretation of Article 8.1, which sort of leaves open the door for any further issues that might come out on appeal or other issues in the future. And he decided that it would be enough to apply to any delay. And so the practical guidance from these comments we take is that it reinforces the need for good contract management. So in circumstances where if there is any doubt as to a delay or an event, issue the notice and communicate your position to the other side. It might be that it's a non-event, or it may be that it's an issue which doesn't stand the scrutiny of a subsequent arbitration. But as this case clearly shows, by failing to do that, you are exercising your rights of self-help. So I'll pass over to Rob for issue 3.
So next slide, please, Andrew. So then there was a further issue which related to modifications, and the builder argued that the parties had agreed to modify the design of the vessels and that delays had arisen as a result for which it was entitled to an extension of time, though it accepted that there had been no agreement on such an extension of time before the modifications were effected. And this is a fairly typical problem in shipbuilding contracts, where the project teams for both builder and buyer have a good cooperative working relationship. And during that period, or during the period of good cooperation, modifications are agreed to be undertaken by the builder without recourse or without sort of a nod to the contractual scheme that needs to be applied. And here the judge, unsurprisingly, gave short shrift to the builder's argument, and he did so based on the wording of Article 5.1, which is fairly common in the market, which set out the requirements for undertaking modifications. And as you can see from the wording in bold, that if due to whatever reasons the parties hereto shall fail to agree on the adjustment of the contract price or extension of time of delivery, which was the case here, then the seller shall have no obligation to comply with the buyer's request for any modification and or changes. And this is, as I say, fairly standard wording. And what it means in practice is that a builder should be very loath to carry out modifications in circumstances where it has not agreed the consequences of those modifications on the delivery date and or contract price, etc., etc. It's also useful normally for the buyer to also want to enter into such agreements because it provides clarity going forward. But again, it's another issue here which sort of reinforces what we would say is the requirement for robust contract management by the parties during the shipbuilding project. Next slide, please, Andrew.
So this takes us to the final issue, which was put before Butcher. Now, by the time that the sort of middle instalments were due on hulls 21 and 22, the parties had clearly fallen out as a result of the alleged defects in the earlier vessels, with the result that the buyer did not pay middle instalments. Now, the builder contended that as the buyer was in breach of its obligation to pay pre-delivery instalments, it was entitled to a day-by-day extension to the delivery dates without the need to take any further steps. Now, this is covered, buyer's default is covered by Article 11, and I've highlighted the particular provisions which are considered by Butcher J as 11.1a, 2 and 4a. Now, the judge stated that given the wording in Article 11.4, the seller may choose that the delivery date should be postponed. It does not so choose the delivery date is not so postponed. So it's not an automatic extension. Now, you might think that Butcher J was trying to incorporate some sort of symmetry between his analysis of Article 8.1 and Article 8.2. But he decided that actually there was not a requirement for a formal notice to be given under Article 11, but simply that a communication from the seller to the builder that they considered that a delivery date would be postponed. This is not necessarily an Article 8.2 notice, but merely a form of communication between the parties. And this just comes back to our earlier points that we've made, that sort of robust contract management, even if it isn't delivering the formal contract notices where there's any discussion of whether that's required, it's about communicating with your counterparty to ensure that each party is aware where another is raising a contractual issue. And that takes us to the summary of the lessons learned.
Next slide, please, Andrew. So what is the significance of this case to shipbuilders and owners? Well, we've highlighted 5 key takeaways, if you like. And the first one is that the English judiciary has again shown its reluctance to apply the prevention principle in a shipbuilding context. They take the view, it seems to us, that the parties to a shipbuilding contract tend to and want to have a complete code of events and the right of the builder to claim extensions of time. This is important. So the second takeaway is the importance of amending Article 8.1 or the equivalent in the shipbuilding contract to make it clear, if it is the party's intention, that this is intended to cover all buyer-induced delay to the extent not covered elsewhere in the underlying contract. So to avoid any issue of the prevention principle arising. I mean, our view is that Butcher's judgment is likely to be upheld by the Court of Appeal. And in those circumstances, therefore, wording as in the Article 8.1 that we looked at here would be sufficient. But there is obviously further clarity could be provided by the parties should they wish to do so. The third takeaway is to ensure that the scope of any contractual notice provisions are clearly drafted. Who is to send what, how and when, important considerations, and that once the scheme has been agreed in the contract, to ensure robust internal contract management processes are in place to track the delivery of the notices and to catalogue the notices sent. And our very firm view on this is that if in doubt, a notice should be sent to protect a party's contractual entitlement. It's much easier to argue about the position later where notices are issued than to try and argue that you didn't need to issue a notice, especially in light of Butcher's very firm view on the meaning of Article 8.2 in this case. And the final takeaway, which perhaps is the most obvious, is to ensure that any modifications are only undertaken. So any modifications to the design or the work to be performed are only undertaken after agreement has been reached between the parties in accordance with the contractual scheme, to make sure that where the consequences of those modifications impact on the delivery date and or contract price or other provisions of the contract, that those are picked up in advance or sent off for determination either by class or an arbitration tribunal, but not left hanging in the ether while the modifications are being performed. So those are the takeaways that we would say come out of this case. I think we appreciate that it's quite a quick run through, and it may be that some of you have questions, and I think we've got time for questions now, unless Andrew tells us otherwise. But even if you don't want to ask them now, feel free to contact either Alex or I after this webinar. We'd be very happy to pick up any queries that you had.
Thank you very much, Robert and Alex, for that interesting and very relevant and topical presentation. For our audience, if you would like to contact Robert or Alex, you can see on the screen here their contact information. So we have a few questions. So
Excellent.
just the first one, which is more relevant to this specific case, is could you clarify whether the buyer was the same party under all the shipbuilding contracts in the series, rather than each having a separate SPV buyer?
That's one for you, Alex, I think.
Yeah, that's right. On this one, yes, there were the same buyers throughout the series. I mean, there was going to be obviously naturally an SPV structure put in place, I think, but that's after delivery.
Okay. Then on a more general point, what implications do the rulings in this specific case have for shipbuilding more generally? And if one were to enter into a shipbuilding contract today, what should they be aware of following this case?
Yeah, I think, I mean, I'd go back to the summary page. I mean, that really sets out what we think is to be aware of. I think the key is to ensure that the contract covers all types of events that may lead to extensions of time or delay, more importantly, and to set out what the contractual scheme is in respect of those, and to ensure that where once the parties have agreed the scheme for any delay events and or any notification issues, that the parties then manage the contract during the construction project. Quite often we find the problems arise where the contract is put in the drawer after it's been signed by the parties and the project teams are just told to get on with the project. And that's fine if everything goes well. But of course, if it doesn't, then the parties will look to the contract. So we see sort of it's very important for robust contract management by both parties. And I don't know, Alex, whether you've got anything to add to that.
Yeah, I mean, all I would add is it's related to this case, but very much topical to the current situation and the kind of work and instructions we're dealing with at the moment with the COVID situation. I mean, the COVID lockdowns that have taken place globally have created a series of situations of delay, which, depending on the wording of the contract, could sit within permissible delay or could sit with some sort of force majeure or frustration type issue. So I think if you're looking to enter into shipbuilding contracts now and going forward, on the assumption that the COVID crisis is not set to disappear immediately, and there could well be resurgences and further lockdowns, particularly during the winter months, I think it would be prudent to consider with some detail the way in which the current coronavirus COVID-19 situation is classified, and if indeed it requires specific notice provisions, particularly from the yard if they're having difficulties with staffing or commissioning or getting external contractors in. So that would be my thinking.
Yeah, no, I think that's very sensible.
Thank you, Alex. One last question here. As a law firm, are you currently seeing requests from owners to delay deliveries of new buildings? Generally, what is the reaction of the shipyards?
I think that's a two-part question. I mean, I think it depends what type of, as always, it depends what type of vessel is being constructed and what the market for that vessel is. I think the delays more recently have tended to be on the builder side because of the difficulties, as Alex has just identified, because of the COVID-19 situation and the ability to get people or subcontractor work. There has been one buyer problem where they couldn't get their crew to the shipyard, which I know about, and in those circumstances, while they were obliged to take delivery because delivery didn't require crew to be there, they had a problem with taking the vessel away after delivery, and that was a matter of commercial discussion and agreement in the end, and both parties took a very sensible approach. But those are the type of issues that we're seeing. I don't think that there's any greater desire on the part of buyers to cancel projects than previously. It's more a case of local difficulties, I would say, at the moment. But I mean, Alex, unless you...
No, I'd agree with that. I mean, it's difficult for both sides at the moment. You've got situations where demand is fluctuating for new vessels of all kinds, and naturally, as Rob has identified, there are real logistical issues which we know and we've assisted with various parties in trying to overcome those. But yes, no different to a usual pattern we would see.
No.
Thanks. And just one more here. Is the signing of a win-win shipbuilding contract the one that passes through the legal advising system, or is it the one through a technical team knowledgeable in shipbuilding and more so in supervision?
I think I would say both.
Agreed.
I mean, yeah. I think a shipbuilding contract is always a matter of negotiation, and so it will never be perfect for both sides, but hopefully it provides a scheme that both parties can work to and can manage their way through during a project, and I think it's really important that is the case, that they can manage their way through the project legally, but also it's very important that they can manage their way through the project technically, and of course if there are no problems during a project, and you've got a willing buyer and a willing builder, then the contract may be needed less often, shall we say, than in a contentious decision where one party or the other is struggling. So I think they're both equally important. But if you don't have a solid legal framework within which the project can be undertaken, then that creates sort of hidden problems, shall we say, going forward, which you don't really know about until the problems arise.
Yeah, and I would just add to that I think Rob's absolutely right. It's a blend of the two, and ordinarily we are asked to advise on many projects just on the contract itself, but it's very important that there is a legal and technical review of both the contract but also the technical specification. And even on some of the more sort of simplistic projects, sort of bulkers, etc., and leaving aside more complex offshore LNG vessels, you often find there's critical contractual and performance standards buried in the technical specification, which often don't come to light before the lawyers. And as Rob says, unfortunately, those critical performance standards for both parties can often only come under serious consideration when it's too late. So always look at your technical spec as much as the contract itself.
Yeah, so a blend of both, we would say.
Okay, thank you, Robert and Alex. Unfortunately, that is all we have time for today. For those of you listening in, this webinar is being recorded and will be posted on our website later today or tomorrow, so keep an eye out for that. We will also send a follow-up email tomorrow with some contact details, so if your question wasn't answered today, you can follow up with our speakers tomorrow. If you're interested in participating in a future Marine Money webinar or becoming a Marine Money member, please visit our website at www.marinemoney.com or contact the Marine Money team. Thank you all again for tuning in. This is your host, Andrew Oates from Marine Money, signing out.
Goodbye.